Mr. Tanner, in April 2005, while you were serving as the voting section chief, Georgia passed the law requiring photo identification in order to vote. Georgia submitted this law for Section 5 pre-clearance. We now know that 4 out of 5 of the Justice Department civil service employees objected to the law and forwarded a 51-page memo to you that included the factual investigation and the legal review of the Georgia plan. Most significantly, the memo included a detailed analysis and a recommendation that the department object to the voting change because it was likely to discriminate against black voters, but they were overruled the next day by higher-ranking officials at Justice. Only one day after receiving the staff analysis recommending an objection, the department approved the Georgia plan. Brad Schlossman and Hans von Spakovsky, both former senior-level Department of Justice officials who served in the CRT, testified before the Senate that you played a key role in the department's decision to approve the Georgia photo identification law. Now, you received the 51-page memo that analyzed thousands of pages worth of information on August 25th. The department received additional information from the state of Georgia on August 26th. The staff recommendation said that it did, the 4 out of 5 staff members who reviewed it said that you ought to recommend it interposing an objection. You overruled that, is that correct?
I made the decision
that they were incorrect and that you should change the recommendation.
I made the decision, Mr. Chairman. I'd like to make that clear. I would, of course,
but in making that decision, you differed from the 4 attorney or whoever, the 4 of the 5 people, the staff people, the permanent staff who recommended a contrary decision, correct?
I'm in an awkward position in that we are not allowed, and it is inappropriate for department personnel to discuss internal deliberations and the confidences of our clients. I'm happy to give you information and explain the basis for my
Mr. Tanner, I believe that that is public information, that has been testified to before I think the Senate. Is that not correct, that this is public, that the 5 individuals who reviewed this, who did all the staff work, 4 of them recommended disapproving and one differed from that? That's all public information at this point.
I'm not aware of the testimony on that. I'm not going to deny it. I will say that I made the decision, and my decision was based on a careful analysis that had been ongoing for a considerable period of time. There were, as typical in such situations, numerous discussions, detailed discussion of the data, and a number.
Before you did that, did you forward that to the front office, or did you get approval from the front office?
The internal memorandum was forwarded to the front office. The matter had been had involved a large number of discussions over an extended period and very careful analysis and review by me.
Now, but is it not true that it was a long-standing section practice for a section chief who disagreed with a staff recommendation to submit a separate recommendation and leave the final decision concerning the split recommendation between staff and section chief to the Assistant Attorney General?
I think that the Assistant Attorney General was fully aware.
That wasn't my question. Was it or was it not a long-standing practice that when the section chief disagreed with the staff recommendation to submit a separate recommendation so that the Assistant AG could see the separate recommendations by the staff and by the section chief, and he could make a decision, or she?
That has not been the uniform practice.
Was it the general practice?
I will say,
I know it wasn't uniform because you didn't do it. Was it the general practice up to that point?
Well, prior to that time, it had not been done.